Hi, Tina. I just want to check my audio. Do we have any clerks on the line?
Hello, Councillor Bly, we can hear you.
Okay, great. I just wanted to double check that my audio was coming through. Thank you.
Good evening and welcome, everyone. This is a business license hearing regarding the Chief License Inspector's decision to suspend the business license issued to Ryan and Mylene McMillan for a short-term rental accommodation at 4010 Inverness Street. Before we begin, I have a few opening remarks and housekeeping items. This hearing is being convened by electronic means as authorized under Part 14 of the Procedure Bylaw, the City of Vancouver electronic meetings. As such, panel members may participate in person or by electronic means. Please note, if my connection is lost during any portion of this meeting, we will recess the meeting until my connection is restored. If a council member attending by electronic means loses connection during the voting process, staff are available to get you back online quickly while the voting process is suspended. The staff contact information has been circulated to the members. Video of council members speaking and vote results will be projected on the live stream when available. For council members participating by electronic means, in accordance with Section 14.13 of the Procedure Bylaw, please ensure your video is turned on and let the clerks know if you leave the meeting. For the purposes of confirming quorum, thank you. We also acknowledge that we are on the traditional and unceded territories of the Musqueam, Squamish, and Tsleil-Waututh nations. We thank them for having cared for this land and look forward to working with them in partnership as we continue to build this great city together. May we have the roll call, please?
Hello, we have Councillor Dominato in the chambers, who is also the chair this evening.
Present.
Councillor Fry, also in the chambers.
Present.
Councillor Bly, viewing remotely.
Present.
You have quorum, Chair Dominato.
Thank you, clerks. We will start with opening remarks from Robert LeBlanc, Counsel for the City of Vancouver.
LANCM litigation counsel with the city, also holding the title of city prosecutor. Do we have the licensees on the line?
Yes, Ryan McMillan is present.
Thank you. Is anybody else appearing for the licensees, Mr. McMillan?
Just myself.
Okay, thank you. I'll address the panel then and we'll get underway. The hearing before the panel this evening is an appeal by the licensee of the Chief License Inspector's decision to suspend the 2021 business license issued to Ryan McMillan and Mylene McMillan on, that was issued on December 30th, 2020 for the provision of short-term rental accommodation at the address of 410 Inverness Street. That license that is subject to this hearing is included in the materials at tab 2. The suspension by the Chief License Inspector and the basis therefore is set out in the letter of October 13th, 2021, and that is too included in the materials under tab 10. And there's a portion of that letter that I'm going to just read from the outset. I have the materials tabbed, but they're also page numbered in the top right-hand corner. Maybe more helpful if I refer to page 64, which is where I'm going to take the panel.
Yes, go ahead.
The synopsis of the decision is set out in the third full paragraph on page 64. This is the letter from the Chief License Inspector, Sarah Hicks. The city has determined that in consideration of the totality of information, including the documentation submitted prior to the meeting, the information provided at the meeting, and the inspection with regards to the living and rental arrangements, the non-compliance with the booking calendar request, and the acknowledgement that you, Ryan, stated that you do not hold a license for, nor are you the principal resident of unit number 2, 4010 Inverness Street. that it does not support that 4010 Inverness Street is your principal residence. As per License Bylaw 4450, Section 25.1 sub 3, no person shall carry on business as a short-term rental accommodation operator unless the short-term rental accommodation being provided is the principal residence of the unit. On that basis, the 2020 license was suspended. The crux of the decision falls on the interpretation of principal residence requirements as outlined in the license bylaw. There is a definition of a principal residential or principal residence unit, and I'm going to read from that because this panel is going to need to take that into consideration. A principal residence unit means the usual dwelling unit where an individual lives, makes their home, and conducts their daily affairs, including, without limitation, paying bills and receiving mail, and is generally the dwelling unit with the residential address used on documentation relating to billing, identification, taxation, and insurance purposes, including, without limitation, income tax returns, medical services plans documentation, driver's licenses, personal identification, vehicle registration, and utility bill. And for the purposes of this bylaw, any person may only have one principal residence unit. The city's witness today in these proceedings is the city's Deputy Chief License Inspector, who will take you through the materials that have been provided in the evidence book and explain the basis for the Chief License Inspector's decision to suspend. What the panel can expect to hear is an indication that the decision required a weighing of the claim of principal residency by the licensee against a number of other factors, namely the high booking volumes of the subject premises for short-term rental accommodation, the lack of documents supporting primary residence with respect to the unit that is being used for short-term rental accommodation, no submission of contemporaneous booking records, which was the latest request from the city's audit, admissions of residency in both units by Mr. McMillan, and further discrepancies with respect to information provided during the audit process. The backdrop to this hearing is essentially the policy or the raison d'etre of the bylaw, which is the city's desire to maintain short-term regulations for the purpose of preserving long-term residential housing stock. And I'd ask the panel to keep that in mind. This is what the Chief License Inspector is required to make the decision for. The Chief License Inspector's submission is that the conclusion that the evidence did not support principal residency was a reasonable one, that the suspension of the license logically flows from that, and that the suspension should be upheld. Of course, the licensee has the opportunity this evening to convince this panel otherwise. Before embarking on the evidence, there are some legal and procedural matters to note. First is that the Chief License Inspector's power to suspend the business license is set out in Section 277 of the Vancouver Charter. That section reads, the Chief License Inspector shall have the power at any time summarily to suspend for such period as he may determine any license if the holder of the license has, in the opinion of the inspector, been guilty of such gross misconduct or with respect to the license premises as to warrant the suspension of the license. And it's the submissions of the Chief License Inspector that the short-term rental of the property in the city that fails to comply with the regulations with respect to principal residency amounts to gross misconduct. This council's power to review a business license suspension is further set out in that section. Any person whose license has been suspended under this section may appeal to the council in accordance with the procedure for that purpose prescribed by bylaw. And upon such appeal, the council may confirm or set aside such suspension on such terms as it may think fit. This panel's power to review a business license is further set out in Section 275 of the Vancouver Charter. The granting or refusing of a license to an applicant, therefore, and the revocation or suspension of a license which has been granted shall be deemed to be in the discretion of council and the council may grant, refuse, revoke, or suspend the license without stating reasons, therefore, save in respect of a licensee who by reasonable efforts cannot be found. The council shall not revoke a license without giving the holder thereof an opportunity to be heard. And of course, that's the purpose of this evening's procedure. Under that section, you have broad powers then, this panel does, to revoke, suspend, or uphold a business license. This is, however, an administrative proceeding. There are rules of natural justice that apply to that. I'd ask the panel to please keep in mind that the license holder is entitled to hear the allegations against them. That includes the allegations through the city's sole witness and the evidence materials that have been filed. They may also respond to those allegations with evidence of their own. They may ask questions of witnesses that are presented, and they may make submissions on their own behalf. If this panel sees fit to uphold the suspension, overturn it, or stipulate conditions on the issuance of the license, the law of the Supreme Court does state that you must give some reasons as to why you're doing so. With that in mind, the city can proceed with the calling of its only witness this evening. That would be the chief or the deputy chief license inspector, Koji Miyaji.
Thank you, Madam Chair, members of council, or members of council and panel. My name is Koji Miyaji. I'm the Deputy Chief License Inspector for the City of Vancouver, and I'm also the Assistant Director of Community Standards. In that dual capacity, if you will, I oversee areas. In this particular case, it's called proactive enforcement, and they're the folks that oversee the enforcement of short-term rental licenses. I also oversee the property use inspections area, and they do the inspections that are related to these files. And so I am familiar with these case files, and I do discuss the outcomes of our findings with the Chief License Inspector as well.
Thank you, Mr. Miyaji. I understand that you have reviewed the file with respect to the subject property at 4010 Inverness Street.
Yes, I have.
And you had some involvement in terms of the short-term rental enforcement activity at that particular premises?
Yes, I have.
What I'm going to ask you to do is take us through one document in particular in the evidence book that is located at tab 3 of the material, starting on page 4, noted in the upper right-hand corner. And maybe just before we dive into the information that's in that document, you can just explain to the panel what this document is.
Yes, through the chair. This is a summary that I've asked our short-term rental clerks, and they're the folks that work with the coordinator and the manager of that area to essentially review and conduct audits and so on and so forth. And so this document is provided, is created to provide the panel with the information chronologically highlights of what occurred in the creation of this case file.
Just for clarity.
Oh, page 4.
Page 4, thank you.
Yes, and so page 4, page 5, page 6, and page 7, and into 8 actually, will summarize quite well the information that I hope to cover pertaining to this case.
And maybe just before we dive into that, you can explain to the panel what type of property it is that's located at 4010 Inverness.
Yes, this property, my understanding is it has 2 addresses. So there are 2 separate dwellings, if you will. And they're identified as, on our records, the city records, as number 14010 Inverness and number 24010 Inverness.
And I'm just looking at the first page of tab 3, which is actually page 4 in the upper right-hand corner. There's reference under the fourth full paragraph with respect to an address change in March of 2020, changing a 410 Inverness Street as the main address and a secondary address of 1210 East 24th Avenue to two addresses under 410 Inverness Street, one being Unit 1 and one being Unit 2. Is that right?
Yes, that is correct. And that was something that we picked up through our process in our research. And that also triggered our investigation, if you will, as well. But the address request, the address change request, my understanding came from the property owner or one of the property owners. And it was to eliminate 1210 East 24th Avenue. That's the unit that's in question, being a short-term rental, and to distinguish it away from 410 4010 Inverness Street, to designate them as two different addresses, and it was for safety reasons in terms of fire, for 311 calls, or sorry, 911 calls, and so the fire folks could see the address and see that they're two distinct locations. And so that request was put in with the property owner, and so to our record, that's where the number 2, 410 Inverness Street came from.
Okay. I'm actually just looking at a property inspection report that is at page 34 of the documents. This is an inspection report filled out by one of your property use inspectors, and it refers to the approved use of the building and the land on the first page of that report, again, page 34, as being a one-family dwelling plus secondary suite.
That is correct.
Okay, so this would be a single-family home that has a separate living quarters on the upper floors being unit number 1, correct?
That is correct.
And the lower floors constituting unit number 2.
That is correct. And so the secondary suite is a legal secondary suite to our records.
So these are two separate dwelling units within the main address of 4010.
Yes, they are.
Okay. Now, you said that the distinction between these addresses came to your attention with respect to the licensing of a short-term rental accommodation at that premises. Is that right?
That's correct.
Can you explain that to the panel?
Yes. So one of the activities that we do is we frequently scan for anomalies in the address and or its structures. And so the clerk, or I should say the clerk, the coordinator, the enforcement coordinator for short-term rentals had flagged that this that 410 or 4010 Inverness, in fact, is a multi-unit dwelling. And so therefore, the license, although states one address, the business license states one address, which is the 4010. And because it's a multi-unit dwelling, we started to investigate to say, well, which suite or which dwelling unit is this license actually applying to?
Okay, and I'm just looking at a copy of the 2021 license, which is page 3 in the evidence materials, and I do see that the address that is particularized on the license is 410 Inverness Street, with no distinction between whether or not it licenses the use at Unit 1 or Unit 2.
That is correct, and that's also a flag for us as well, because these are self-filled by the applicant, and this was issued in December 30, 2020. The address change and the request occurred in March 2020, and so the applicant, who is the property owner, I suspected would have known about the address change at that time.
Okay. So it was flagged because I take it there's no such single dwelling unit as 4010. It has to be distinguished as either 1 or 2. And so there was some further investigation as to what was happening.
That is correct.
Okay. Can you just pick it up for us then, maybe with the entry noted to be June 1st, 2020? This appears to be the first action that was taken by the STR short-term rental license team with respect to inquiries on the license address?
Yeah, so as our initial follow-up, this is June 1st in 2020. Our coordinator, Alexander Holmes, spoke to Ryan, I believe, the property owner, and wanted to know that they're advertising the legal short-term secondary suite for short-term rentals, but wanted to know which unit does the license apply to, and the property owner, Ryan at the time, and it says here, he wanted to know how to resolve so that they can keep doing what they're doing, which Alex, of course, had said that, well, you can't continue to do that because you have to live in that unit that you're renting. They thought about geo-being, so that's a term that we use that's gone out of business. So they talked about, well, maybe you want to cancel your license, essentially. And the conversation continued on, and to a point where we clearly explained to them that you can't continue to do that. We will permit you to continue with if you to honor your booking for that immediate time, but you can't do that going forward. And if they chose to do so, that we would then continue our investigation and audit the license further in terms of their activities.
Okay. I'm just going to paraphrase maybe what you said, and what my understanding is in terms of the notes from that paragraph is that Ms. Holmes was advised by the licensee, Mr. McMillan, that they were living upstairs and using the secondary suite downstairs for short-term rental purposes.
That is correct, and that was the nature of the context, and that's what Alex said, that you couldn't do that. You couldn't live here and rent down here.
And that's because the downstairs unit constitutes a separate dwelling unit?
Yes.
And they weren't the principal residents of that basement unit?
From the information that we obtained then, yes, the reference was that they weren't living there, but they were renting the vacant secondary suite.
Following Ms. Holmes's conversation with Mr. McMillan, what further action was taken then?
Well, so we said that we would continue then with the audit, and the enforcement process is such that we would then request for the first phase is we call it a mailing audit. That's a term that we use, but it's documentation check is what we do, and so we requested that.
Maybe just before we get there.
Sure.
It appears as though in the following paragraph there was some follow-up with Mr. McMillan the next day by one of the clerks in the STR office, and a different version of the living arrangements was provided. Yes,
that's correct. In that particular conversation, I believe it was Sarah that he was talking to one of our clerks. He had said now that that they're using the downstairs as I believe Ryan was using the downstairs as his primary residence, and his wife was living upstairs. And then whenever she goes out of town, that's when he'll go upstairs and book out the lower suite, and so he's saying that he's using the primary residence claim for the secondary suite, and then while his wife's away, he will book. We'll talk shortly about the number of bookings that he's had to sort of question that validity, but that was the story that we had heard the next day.
So over the course of a couple of days there, June 1st and then on June 2nd, 2020, we had two different clerks in the short-term rental team report two different stories received by Mr. McMillan with respect to the living arrangements at the property.
That is correct.
And on the first day, it appears as though there was an indication that he was residing upstairs, and he and the co-licensee were renting out the bottom floor as short-term rental accommodation, and then the following day an indication that in fact no, they were separate, living in separate units. One of the licensees upstairs and he downstairs, and he would rent out the short-term, rent out the lower floors for short-term rental accommodations when he could, and then would move upstairs while it was being rented. Is that a fair characterization of the two different versions that
Yes.
you received? Okay.
Yeah, in 24 hours, we had two different versions of how they lived.
So having received those two different versions, having seen a license not particularizing either of the two units at 4010, you mentioned an audit. I take it that those discrepancies triggered the audit process under the regulations?
Yes, they triggers what we call a mail-in audit. Sorry, that's what I was saying before. And through the chair, the results of what we obtained are also identified on page 5, which I can get into. At this juncture of the audit, we look for documentation that supports where the activities, where the license is issued or is supposed to occur. And the information that we obtained did not support number 2, 4010 Inverness. In fact, the documentation showed that it was still the main house. Now, we received this information in November, so there was plenty of time there to see or for them to reflect the address change. And for some reason, we did not receive any information that reflected the address of the secondary suite.
I'm just reflecting back on that definition of principal residency that I read from the license bylaw. And it indicated things like bills and insurance and documentation indicating principal residency. That's why you're asking for those documents in particular. And I see here insurance agreements, driver's license. That's what a BCDL is, correct?
Correct.
BC Hydro bills, Fortis bills. What you're looking for there is particularization in those documents indicating that the licensees are resident in a particular unit. Is that correct?
That is correct. And specifically where the short-term rental is occurring.
And in this case, we know that it's occurring in unit number 2 because that's been told to us on a couple of occasions. But none of the documentation indicates that either Mylene McMillan or Ryan McMillan were permanent residents of unit number 2 at 4010. Is that right?
That is correct.
In fact, all of the information that was provided reflected only 4010 without particularization of either number 1 or 2 unit on the documents.
That's correct, despite the address change request put in March of that year.
But the 4010 was always the address for the upper unit, even though it was later changed to be particularized as unit number 1. Is that right?
That is correct.
So in this case, you didn't receive any documents supporting primary residence of unit number 2. I see in the paragraph that follows, you appear to have asked for booking calendars.
Yes, and that is a standard process for us as well for license holders that have had short-term rental activity. We like to look at the booking activity. And as you can see here, from what we received from April to October of 2020, these are extremely high booking numbers. And if you bear with me with the percentages, you know, the April bookings equal 73%, May bookings equal 100%, 65% or 60%, 65, 94, 90, and 77, which reflects October. Overall, that's 70% of the total time for that particular secondary suite is booked for short-term rental activity. to us, that's extremely high. And two, it makes it difficult for us to understand how a 70% completely booked facility is a primary residence for somebody. Some of these places that are booked 100%, 94%, 99%, that's 3 months, if you will. That's completely booked. And so for us, that's another trigger for us to say that we don't think that is somebody's principal residence to the degree that it's booked.
Thank you. I'm just doing my own math, and I came up with different figures, but maybe you can just tell me if the totals are correct. I have over that period from April 2020 to October 2020 as being 171 days out of 214 that were booked for short-term rental accommodation.
Yeah, I was talking percentages.
Okay, thank you.
Yeah.
I take it from that you've determined that over that period, a principal resident of that particular unit would have to have only occupied the unit for close to, less than 50 days over a period of 214 days.
Yes, yes, it's extremely low to be considered. That's where you do, in terms of the definition that was provided earlier, as a primary residence.
Okay. Now, then, having received the booking information indicating overwhelming number of days being used for short-term rental accommodations, and having not received any documents indicating principal residency in unit number 2, what enforcement action was taken at that point?
So with that information on file for us, we decided to further have an audit, and that's the interview audit. That's the second phase that we do. We started that conversation with them November 5th. And the different timeframes that you see there are conversations that we've had with them, or contact or lack of contact. And we recognize people are busy as well. So we try to accommodate as much as we can. But with that understanding, from November 5th, we were able to finally nail a date in February 2nd of 2021 to be able to have that interview audit.
And I see here that Mr. McMillan attended to an interview with Claire Thompson and Andrew Menzies. Can you just tell the panel who Claire Thompson and Andrew Menzies are?
Yes, Ms. Thompson is the manager of proactive enforcement. And so, and she and Alex Holmes, I used to do that myself as well, do the audit interviews. And so Ms. Thompson is the manager, and Andrew Menzies is one of the clerks that works to support the audit process.
And I see that in the evidence book, starting at tab 6, page 20, we have 2 sets of notes with respect to the interview. The first set of notes made by Mr. Menzies, constituting pages 20 through 25, and then Ms. Thompson's notes starting at page 26 onwards.
Yes, that is correct. Correct.
You've reviewed those notes of the interview?
Yes, I have.
Can you relay to the panel what further information was discovered with respect to the units?
Yes. So with this audit, I'd like to maybe take you to page 22, and we try to ascertain from the property owner or the license holder the circumstances that we see, and we certainly wanted to ask more about the high booking numbers and how they've had their explanation of how they reside in terms of the secondary suite and the main house, and so in different passages, and I won't necessarily go through all of them. If you look at page 22, in RM stands for Ryan. he talks about when Ms. Thompson, CT, asks questions about what do you mean using the entire house for secondary suite. Uh, 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 Ryan says that he has marital issues, and so most of the time I'm living downstairs. She lives upstairs, so sometimes we do share accommodation. So that's one explanation. If you go further down that page, on page number 5, Ms. Thompson asks about the conversation that they had earlier with Alex Holmes and also with Sarah, who is the other clerk, about uh, their living, if you will, or how they're using the short-term rental in the secondary suite. And Ryan at the bottom essentially says, "I don't remember saying that." So where Claire says, "Well, it says here that you live downstairs, but you have extremely high bookings." I'm kind of paraphrasing, and he says that some of them were shared with guests, others was out of town, others she meaning his wife was out of town, so we made arrangements. I would stay upstairs, and then he says, I don't remember saying that to the first person, which is Alex. So either was misinterpreted, and so on and so forth. It continues on to say in page 23, where Claire Thompson asks, can you provide evidence that your wife is out of town, was out of town during the bookings, as you stated? That's when you stay upstairs. And Ryan says, yes, I can. Some other days we were in both space. Um, the comment that we'll come back to later is that he's indicated that he has proof that his wife was out of town during those times that the bookings occurred. And so later on, you'll see that we were waiting for that information to come forward, and we never did receive it. He continues on to say that, Claire says that I'm concerned that you're not living downstairs, that you're living upstairs. And Ryan states that it's my house. And she says the secondary suite has a different address. And then where do you keep your belongings? And he says in both upstairs and downstairs.
Maybe I can just
Sure.
ask what you drew from the interview. I'm looking at some of these things, and it appears as though the information that's being told to Ms. Thompson is that essentially the house is being used. Both units are being used by the licensee.
Yes. In sort of summation of the audit, which helped to firm up the decision of the chief license inspector, is that the audit information we found really didn't help Mr. McMillan explain how he's operating the short-term rental, in the sense that we were questioning his primary residency in that secondary suite, and the audit process did not fully explain to our satisfaction that is his that is his primary residence.
And just getting back to that definition of primary residence that I read from the license bylaw, somebody can't have two primary residences.
No, they cannot.
So we can't have the licensee claiming primary residence for one unit while simultaneously acknowledging that they're living in both.
Yes, that's correct. And we also got the impression that through the audit process that Mr. McMillan wasn't, he indicated a couple of times that it was his house. And he didn't come out and say that I could do whatever I want, but I think the inferences were there that, look, it's this, both of these properties are mine, and that, I'll stay where I want when I need to, was the other inference that we got. And unfortunately, for the definitions of our bylaw, in the spirit of the short-term rental activity in the bylaw, there needs to be better clarity there in terms of how he is living.
And I'll just get back to maybe a comment that I made at the beginning, which was the purpose of the bylaw is to preserve that long-term rental housing stock. And we have a basement unit here that's approved for that purpose that's not being used for that purpose. That's essentially what you're saying.
Yes, that's exactly true. In page 30, Claire notes that what Mr. McMillan says is, I understand 2 legal suites. I can do anything I want. I can do whatever I want with this suite. I own the suite. My name's on it. If I need to change it to number 2, but I didn't is kind of what he said. So, but those were quotes that were picked up out of the interview, and so therefore we felt that it wasn't being complied with as per the bylaw.
Okay. I just want to ask you about one passage that you read, which was at the bottom of page 22. Well, maybe just at the top, I'll just contrast 2 things. First, you'd read in that he indicated that he lived most of the time I am living downstairs, is what the notes reflect.
Yeah.
Yet at the bottom of the page, what he indicates is that he's talking about the guests. Some of them were shared with guests. He's talking about the short-term rental accommodations that were provided, correct?
That's correct.
Okay. So the claim that was made by Mr. McMillan at the time is that he was still in the unit on some occasions when it was being rented for short-term rental purposes.
That's how we understood that
Okay.
passage to be.
There's reference in a couple of the documents in the package in terms of how the unit was marketed. First, let me just look at page 67 of the evidence materials.
Yes.
And I'll just ask you to explain what this is that we're looking at here.
So this is a information that we get from host compliance. It shows briefly what the booking is, or I'm sorry, what the listing is. It's pulled from the actual listing. The information that's we're interested in is if you go to the bottom right-hand corner of the page, it talks about documented stays. It says time of activity, and it lists the number of documented stays.
Those are stays, not days.
That's correct. Those are stays now. So this doesn't identify exact number of nights, but it picks up from the listing activities the number of documented stays. So one documented stay could be 2 weeks, and it goes to January 22nd, and it goes backwards, and it's got 4 documented stays in October, 4 documented stays in September, 4 documented stays in August. Those could be a week long, or maybe they're single days, but they're indications of activity. And if we consider what was being done in what was submitted and explained to us in the 2020 activity, there may be an assumption that these documented stays reflect weeks, perhaps, meaning that they could be high stays in terms of usage.
Okay. The detail in this document I wanted to draw your attention to was in the lower left-hand corner under listing details. As I understand it, the listing details reflects the marketing characteristics with respect to what's being offered for rent under this particular listing. Is that right?
That's correct.
Okay. And this is information that's taken from and reported to us directly from Airbnb?
That is correct, from that listing, and it does show that it lists as an entire home.
It's not listed as shared accommodation or a single room in a home.
No, it does not.
So listing title, spacious, modern, 2-bedroom, close to restaurants, would be under room type, entire home, apartment. It would be that entire 2-bedroom unit number 2.
Yeah, that's exactly right. This is directly from the Airbnb site, and it picks up the key information that's there.
Okay, and I also see that under tab 5, starting at page 12, Mr. McMillan provided us with his booking calendar. Some of those dates we've already gone over, but I'm just going to draw your attention to page 13. where he's provided a screenshot of his booking calendar, and it appears as though that information matches the information that was provided to us from Airbnb, being that it's marketed not as shared accommodation, but as spacious and modern two-bedroom laptop station minutes to downtown. That would be a self-contained unit.
That is correct.
You seen anything with respect to this particular property? Any information on Airbnb or anything submitted by Mr. McMillan that would indicate it was ever offered for rent as shared accommodation?
No, we do not have any of those indicators, nor was it stated before, only in the audit that it was stated in that context.
So when we take a look at the numbers that we've just taken a look at, 170 some odd days over a period of 210 some odd days, those days would, to your understanding, be for the entire unit, not for shared accommodation where Mr. McMillan is resident in the unit.
Yes, that would be the conclusion that we reached based on the high number of bookings and the popularity of the entire suite.
Thank you. Going back then to the notes that are under tab 3, I think that we were on page 5. The audit meeting had occurred, and I'm just taking a look there that there's some entry information towards the bottom of page 5, February 2nd, 2021. Some information in terms of what information was obtained from Mr. McMillan. There was again another request for some updated booking calendar information from November 1st, 2020 through to the end of 2021. And I take it that request was made because this audit meeting was happening sometime after the audit process was undertaken.
That is correct. And so
yeah, go ahead.
Oh, sorry. My apologies. The audit triggers a number of questions, obviously, the interview audit. And so we asked Mr. McMillan, through the information that was provided in the audit, three things as a follow-up that he would need to provide to us in order for us to make make a decision. And those 3 things are the current bookings, which he's provided to date, but after the audit, we would like to, or I should rephrase, out of the audit, there were 2 things that were driven out of there, but we also needed to do further investigation as well. And so we had asked for a operation summary, or operation plan is what we call it. There was also work without permit that was flagged there. And so, and that was also pending investigation or inspection. We had also said that we were going to do an inspection of your property. And so out of the audit, there was an inspection that was drawn. And on the on-site inspection, there was some work without permit that was being looked into. That in itself triggered some delays in terms of concluding the information that we obtained from the audit, as we needed to see if the work without permit was going to be a hindrance to our decision making. And it turns out that in I guess August 31st, we had gone on site, or we had then received information from another inspector to say that the work without permit is okay, that it's done okay, and they passed that piece. So with that information, we continued on with the audit to obtain still the operating plan. And by this time, it's October, because we had to do the work without permit inspection. So in October, we had asked again for another current booking information.
Okay. Maybe just before we get there,
Sure.
I just want to backpedal a little bit to the conclusion of the interview. Out of that interview, just to maybe summarize what you said, Mr. McMillan indicated that he'd done some upgrades to the unit, and you You wanted to send one of the property use inspectors to go and just make sure that the scope of the work isn't something
That's
that
correct.
required a permit? Is that fair to say?
Yes, sorry, I should have included that part. Yes, in the audit, there was some discussions of some work that was done. And so, yes, that triggers an inspection on our end. We would do a site inspection, but this also triggers a work without permit inspection as well, which is a bit more detailed.
So that's one thing that you wanted to follow up on before making a decision through the audit.
Correct.
The other thing was that you wanted to get some more updates in terms of the booking.
Yes.
You wanted the operational information.
Yeah, the operational plan is always something that we also ask for as well. And so therefore, to give us better idea of how this person intends to, or has been operating and intends to operate.
Okay. And you further wanted information with respect to Mr. McMillan's wife's travel arrangements so that you could compare that to what he's reporting.
That's right. And that was the third piece, is that in the audit, he had explained that he goes downstairs or he books the secondary or the short-term rental when his wife is out of town. And so, and then when we asked him, can you provide that information to collaborate what you're saying? And he indicated he could. So therefore, we asked for that information.
Okay. So those are the four things. He did submit, and I'm just on page 6 now. He did submit on February 16th, following the interview, an updated booking calendar.
Correct. That
And-
which
and I-
goes
Yep,
which goes
sorry,
to
I'm
November.
just going to summarize maybe what
Yeah.
he submitted. So as of February 16th, 2021, he indicated that the bookings, he provided booking details for November, December, and February, but not January 2021.
No, we did not receive that.
Okay. So maybe leaving aside the future bookings, by the looks of it, on the 3 months for which he provided booking information, I'm counting 77 days out of 89 days were used for short-term rental accommodation.
Yes, that is correct.
The following month, we have a further 12 days booked, and nothing yet booked through May through October, but then all of November had been booked.
Yes, and just doing the quick percentage of that. If we take out the March, which is the 12 days, which is 39%, those days, November, December, January, February, and then November, they work out to 97, 81, 81, and 100%. And then, of course, 39% for March. If you leave out the 39%, it's 90% of the time is booked, is the information we got at that time, which once again is extremely high. March, April, May are low booking months for short-term rentals traditionally, which is understandable, but these other days are extremely high.
Just going down page 6 then, I see that inspection took place with a PUI, that's property use inspector.
That's correct.
That was on March 23rd. And there was a report from the property use inspector in terms of information that he received from Mr. McMillan in the course of the inspection. Can you share that with the panel, please?
Yes, so the report is on, where's that tab? My apologies.
The inspection report is at tab 8, starting at page
At tab 8, yeah.
34.
Tab 8. And in that report, he talks about what he observed and what he heard or talked about. I'd like to note that he had spoken to Mr. McMillan, and during that inspection, Mr. McMillan was there, and Mr. McMillan had cited that he lives in both the primary dwelling unit on the main floor and the secondary suite on the basement floor, and that the basement floor is used as short-term rentals. Mr. McMillan stated that he has had discussion with our staff regarding so on and so forth about doing 30-day bookings as well. Now, once again, the 30-day bookings would also point to, well, then how do you claim that as your primary residence? And then in the booking report continues to show various pictures of the facility. Um, and these pictures resonate fine in terms of what we consider to be a legal secondary suite. Um, but the inspection report does cite some interesting comments that was made by Mr. McMullen that supports some of the information that was stated earlier.
Thank you. I understand following that inspection by the PUI, there was a note of some discrepancy between the layout of the basement or the bottom floor unit and the approved plans. And so it was referred to a building inspector to check and make sure everything was okay.
That's right. There was a minor work without permit identified. It says on their basement floor interior alterations to alter approved kitchen layout in the authorized secondary suite without permits. So the kitchen layout wasn't exactly what the plan had indicated.
The building inspector, though, followed up on that and conducted their own inspection and made sure that there were no issues with respect to concerns or permitting issues and whatnot.
That is correct. We forward that to our building inspector friends, colleagues, and on, I believe, August 31st, it was indicated that the work without permit was minor and that there's no safety issues there, so it was passed.
So following that, now we've had the inspections take place, satisfied with respect to the premises. I'm looking here at the entry on page 6, September 16th, 2021. Due to updates in audit process since initial meeting, email sent to request an operational summary and updated booking calendars. So we're still waiting for an operational summary, looking for another booking calendar, and by this date I understand there had been no information shared in terms of his wife's travel schedule.
No, nothing was received. No information were received, and so therefore, yes, we continue to ask for that information.
Okay. Following that September period, I see here second last entry on page 6, October 5th, 2021, operational summary was received by email, but the updated booking calendar still wasn't included. Page 7, entry October 12th, 2021, no further communication, and the booking calendar has not been submitted. So by that date, I take it you make a decision. You're missing the booking calendar. You're missing you do get the operational
Yes.
report. You're satisfied with that, though. We don't need to go into that in any detail. You still don't have an updated booking calendar, and you didn't get any submissions with respect to the traveling schedule.
No, we did not.
Okay. So a decision was made as of October 13th, 2021, and just tell us what decision was made.
Yes, so based on the information that we've collected to date and then reviewing the audit information from both the document audit and the interview audit, and then once again, the information on the bookings and the information that we didn't get, we based all that into the discussion with the chief license inspector and concluded that that we feel what the information that we have that it does not support that Mr. McMillan lives at the place where he does short-term rentals, and so the non-primary residence indicator was strong enough for us to go with that. And so the letter was sent out on the 13th, I believe it was, or no, when was it? Sorry, or October, I forget the date.
October 13th. That's at tab 10, starting at page 63.
Yes, October 13th. The letter that was mentioned earlier was sent out as a decision of the chief license inspector. And it really is the totality of the information that we received. And I want to appeal to the panel that we don't make these decisions lightly.
I characterized some of the evidence that I expected to come out through you and in the evidence book and in my opening comments, and I'll just ask you maybe to comment on that. The factors that I think come out in terms of what you're telling us and what we've read was that first there was extremely high booking volumes that would interfere with anybody's ability to live in the unit on a primary basis.
Yes, yes. We feel that there were essentially actually four breaches of the sections of the bylaw, even though we cite the primary one. The extremely high bookings is an indicator for us to say that it would be very difficult for somebody to claim that as a primary residence, given it's booked 70, 80% of the time, in some cases 100% of the time in the month. It mirrors what we consider a commercial operation, where a location is used primarily to have short-term rental bookings, and the bookings are characteristics of that. The information that we obtained in terms of how he lives or where he lives, and then we are not passing any judgment on that, but we're using just that information to ascertain if that is a primary residence, and we weren't able to make that determination. The other bylaw violations that we cite here, although may not be specifically identified, but helped us make that decision, is that Section 14A, to provide primary residence documents, he failed to do that. We gave him ample opportunity. None of his documentation reflects number 2, 4010. And in the audit, we asked him that, and he cited some other reasons why about it's his house and he likes to stay where he feels it's appropriate for him to stay. The other breach is Section 14, subsection G, where when we ask, the Chief License Inspector has the right to ask for booking information. We received some, but the important ones that we wanted to look at when we made our decision, none were forthcoming. And then the last one, other relevant documents, which is Section 14, subsection H. And that's the information about his wife's travels. He offered that up, and so that's why we accepted that. And so that became a piece of information that we were also hoping to get, and he never provided that as well. So in totality of these 4 breaches of the bylaw section, we felt that unfortunately Mr. McMillan appears to be operating a commercial type operation, and that it's not in the spirit of the short-term rental bylaw, where occasional bookings are used to augment where your primary residence is being used as a secondary or short-term rental. And so hence, with that totality of information, which is referred to in the letter from the Chief License Inspector to suspend his license.
Thank you. Those are all my questions for Mr. Miyaji.
Thank you. I'll now invite panel members to ask questions. And if you have questions, please put yourself on the queue. No, I don't see any questions. Oh, no, I spoke too soon. Councillor Bly, go ahead, please.
Thanks, Chair. I just have a question to staff, and maybe Councillor Bly will have questions as well, but just as an initial question, on the issue of the better part of a month being booked out, I think that was the language used. I'm just scanning the bylaw again. Is there any limitation to how many days in a particular month are allowed to be booked out?
Through the chair, there is no specific number that's cited in the bylaw. And my belief is that that is done for a reason, to determine reasonableness. and so therefore it's not prescribed in that manner.
Can you remind me, is it prescribed on an annual basis?
Through the chair, no, it's not as well, and I believe for similar um, considerations, it's the degree of reasonableness, and the spirit of the bylaw once again is for some rental to occur, and the primary residence consideration needs to be uh, taken into consideration, and it's not prescribed by a number of nights.
I see. Can you confirm that there's an internal door connecting both the upper and lower suites?
Through the chair, I believe because they are defined as two independent suites and it's a legal secondary suite, I do not believe there's an interconnection there.
Okay, I do recall in a recent situation where there was not an connecting or adjoining door in a basement suite, that the short-term rental license was not able to be granted at all. So I just want to get our legal team to comment on that. I believe it was Ian Dixon who was representing the city at that time in terms of our legal team, but there was that question raised. So I'm just trying to reconcile the difference between this situation and that situation.
Oh,
That may be a question for me. I don't know that situation. I don't know the facts there. I can say that my dealings with secondary suite enforcement are that if there's no interconnection and the city has approved the use of the premises as being a single family dwelling with an approved secondary suite, that constitutes two separate dwelling units. In that case, those two separate dwelling units would require individual short-term rental licenses with their own principal residents operating the short-term rental accommodation.
And so this short-term rental license there was a lot of dates flying around, the old date, then the number 2 of the Inverness date. So just confirming that this short-term rental license, I'm going back to the top of my documents here, is attributed. Yeah, so this short-term rental license is attributed to the address 4010 Inverness Street, correct?
Correct.
But what we're talking about is the short-term rental accommodation that is of a different address.
There is technically no address for 010 Inverness. I think that what the evidence has come out.
Can a short-term rental license even be attributed to an address where the accommodation area is a completely different suite from the address and does not have an adjoining door? I think that we went through this process, and it was once it was discovered that there was no adjoining door, it became a pretty black and white situation. Right now, there's a lot of nuance to this one, and I just want to be very clear that we're not missing that piece that seemed to be quite defining in the previous. I actually think it was the last public hearing a couple weeks ago.
We're getting into sort of the minutiae of submissions. My comments may be best left to the end for that purpose in terms of submissions, because I maybe I'll take issue maybe with the comments.
I'll just jump in as chair. Is the reference Councillor Bly is making is to a business license hearing. I believe it was last month, and I'm certain the clerks could, if need be, find that. And that's the precedence I think she's referring to. And so perhaps we can look for that information in the meantime. Because I think I sat on that panel with Councillor Bly, so I know exactly what she's referring to in that context. Councillor Bly, did you have any further questions?
No, I'm happy to sort of leave that for now and hopefully just get that clarification when available.
Yeah, I think that would be great. I also have some questions. But before I go ahead, Councillor Fry, do you have any questions? Oh, okay. I just have a question to our staff and council is just reconfirming my understanding is that we suspended the business license October 13th, 2021. Is that correct?
Through the chair, yes, that is correct.
And is it
Through the
correct
chair.
that based on information in the evidence documents presented here, I see that there was bookings in November of 2021 and documented stays in January 2022 after the business license was suspended. Is that correct?
Yes, Madam Chair, according to our information, our recent information says that there has been booking activity after the suspension notice.
Okay, so just from my understanding then is that the short-term rental has been operating without a business license at this location.
Technically, yes.
Technically, yes. Okay. Thank you. If there's no further questions from the panel, then I believe it is now the opportunity of the licensee, Ryan McMillan, on the line to ask questions of City of Vancouver witness.
Yeah, thanks for taking the time. Just I don't have too many questions. Just a couple in regards to my wife's travel. That was discussed over the phone, but then sort of my understanding was sort of left. There was nothing in writing that I recall that indicated that you wanted further documentation in that regard. As far as I gave you the operational report and basically tried to work with the city as much as I could. I was pretty cooperative, but yeah, just it's as far as there has been some gaps, and then I guess another question, your last question there, as far as operation without a license. When I got the suspension notice, it did also say that I'm allowed to appeal in a certain period of time, which I obviously have. But then basically my understanding was keep the operations going until like we have this meeting and things are concluded like that. But so as far as that was concerned, and I also tried to reapply. Um, and then I talked to someone in the city, and they also told me that yeah, it's under review. So just wait for your hearing. I said okay. Um, so yeah, and then as far as the what was it? The I
Ryan,
guess
can
just,
Ryan,
yeah,
it's the
sorry.
chair. No, I'm just going to interject really briefly, just to specifically offer you the opportunity to ask questions to the City of Vancouver witness, because after that
Okay.
you have an opportunity to present
Okay, yeah, no problem. Okay, so I guess the one question I had for him, when the property use inspector, I guess, was he sent down from you guys to specifically, because my understanding he was sent down to just check on, like you said, the if there was additional work done without a permit, but my understanding he was just there to look at that and then also to check on fire codes was what he told me. But so was he there for other reasons? Because I guess that's my question. Because my understanding he was just there for those two things, not to give feedback to the city as far as how my operation is going or what my living situation is and all that extra stuff. So I guess that's my question. Was he sent there? Because what I was told, he was sent there for those specific reasons, not for the other reasons that he stated in the report.
Yes, through the chair, the inspector is there to check for compliance. And so he may come across a number of things that may require that. Safety aspects are always part of the inspection. The things that he notes in the report, he certainly wasn't necessarily asked to go and interview you or anything like that. But the inspectors are to note any information or conversations that occur that that may be pertinent to secondary or short term. I keep calling it secondary suites. My apologies. Short term rentals, and so the information that he provided was based on just his observations, and his observations are to be noted in the inspection report.
Thank you. Ryan, did you have further questions? Ryan?
Yeah, sorry. Just I guess I'm just confused about when I was asked to give. I understand, like I on the February 2nd phone conversation. I know that was discussed, but as far as the travel documents were concerned, I'm just wondering where if there was an email asking for those travel documents. I'm maybe I missed that, but I never uh, I didn't see that as far as you guys asked me for those documentations when like when I gave you the operational report and stuff like um, that's so I'm just looking through my notes and maybe I missed that, but was there was it in writing there when you were asking me about the travel documentations?
Through the chair, it was it was clearly stated in the audit that you can provide that information, and so I believe Ms. Thompson had asked for that information. Uh, I'd have to check my notes to see if it was actually asked as a follow up afterwards, but I know it was clearly stated in the audit, and and it is information that um, was willingly provided. So therefore, we followed up on it. I believe Ms. Thompson did ask, "Can you prove that?" And you said yes, and that you would provide that information. And I think she said, "Well, we will ask for that information as well," or somewhere along those lines. Um, I so with that understanding, we had continued to ask for that, and I believe in one of the conversations, Andrew uh, also alluded to that information because he states that he hadn't received that information yet as well.
Okay, I mean, I guess I was just asking as far as in writing documentation. I mean, that you know, because I know things get discussed on the phone, and I know that was a topic of conversation. And but as far as you know, seeing it in writing, I don't recall that. I guess the other question I had in regards to my calendar booking, just I guess obviously you know the high number of bookings you're determining that okay, well this is run for you know commercial use or whatnot, and obviously we didn't get into you know my personal side that has also been well documented through this whole process. But you know that being said, like I did express that it has been sometimes a shared, sometimes not. Just you know not getting into all that marital personal stuff, but so and I also did provide some documentation backing that from people who have visited me and whatnot, which also was not discussed in your report here tonight. But like I said, so to me the calendar is I understand for you, but to me I'm just based on you know if I only had it feels like you're determining it based on like a 70% booking. Whether you know if I had a 40% booking, you it's like you come to a different conclusion. Is that correct based on where I'm living and whatnot? Is
Uh, if that's a question to me, yes, through the chair, uh, we go with the totality of the information that we receive or don't receive. So in your particular case, yes, you had very high bookings, and then we didn't get further information that would help us ascertain maybe if you had lower bookings. As we indicated earlier, the bylaw does not indicate a particular number that determines your primary residency. We look at the total information to make that determination.
Thank you. Ryan, do you have further questions?
I think that's just as far as the uh, I guess some of the documentation that was left out. Just sort of I'm asking him a question again. Just how why was that not presented as far as saying, you know, maybe these are some of the reasons that yes, he has uh, shared occupancy with past guests, and I understand the times. Some like I'm constantly changing the booking, and I understand. Sorry, the advertisement, which you can do on an hourly basis with Airbnb. But so I guess my question was, why did you leave certain things out that sort of showed that yes, maybe he actually is sharing with guests at certain particular times, and then he isn't and whatnot. So I'm just wondering why was that some of that information left out?
Through the chair, we believe we didn't leave anything out. We took the information that's on the website, that's publicly seen, and that information says the entire home. And so there was no indication to us, only in that one statement that you made in the audit, where you briefly said, "Yeah, I share the place with the bookings as well as all these other things." And so we don't have any information that indicates it's a shared bookings. Other bookings that have shared bookings are very clear about that, so that the people that book understand that there'll be somebody else also staying there. In your case, we didn't have any of those indications in your bookings or in your advertising, I should say.
Anything further, Ryan?
I think that no, it's good for now. Thank you.
Thank you. We're now moving to the section where the licensee and you, Ryan, are able to offer your opening remarks and to also call any witnesses if you have a witness. So I'll turn it over to you, Ryan, if you'd like to speak further.
Thank you. Yeah, just reiterating some of the ongoing investigation. Yeah, I mean, we've had obviously numerous. So going back to the start when the first audit. So basically, why the reason behind the short-term rental for us was we've had some issues personally, and with keeping the house, this was the most flexible way to do it. So I understand what the bylaws were, but my feeling was that because I was occupying the downstairs, that I felt that we could make that work in our case to supplement income, and that was the goal. Like it wasn't to run this commercially, make a lot of money kind of thing. I mean, I understand the low vacancy rate in the city. I understand the area I'm in. I could have a lineup of people to rent it out to. So it wasn't this I can make all this money. It was that this in our particular situation that I needed to just if I could rent out a week, rent out 2 weeks, shared accommodation, sometimes just any kind of supplement income based on our situation. That was the reason, and I felt that I wasn't like breaching any of the bylaws. And I understand it's two dwellings, even though it's it's a single family home with two dwellings. I'm aware of it. I just felt that, and I was trying to work with the city over these conversations. So that's like there's not much more to say about that. I mean, and then just as far as even moving forward to present day, just in our situation, just with the price of housing, and just moving that if I go to a long term, that it's going to be very difficult for one of us to say whatever our situation is to find housing. So that's sort of the main. That's like the only reason we've been doing what we've been doing, and I've tried to work with the city. Now I know with the first phone call, like I said, I have stuck with the same thing. When he said within 24 hours, I changed my story. I did say I don't recall that, so I'm not sure. When you're having a phone conversation, that's why it's harder because she said, he said, and so I'm not sure what the first person heard, but the 24 hours later, I mean, I'm not going to come up with some complete bogus story. I mean, this is from day one. It's been like this, and then I've tried to work with the city to provide the documents. There's certain things that maybe I didn't provide, which I didn't understand, or we had that phone call, but I didn't know it was it wasn't anything in writing. I tried to provide, right? Any emails was mostly communication I tried to provide. But yeah, I just moving forward. Like I said, I'm not I'm just asking the to cities to look at my current situation. I understand the bookings look like this, you know, yes, they are like at a 70 percentile, but some of those bookings were shared, some weren't. It was communicated with guests prior to the bookings. The advertisement has changed throughout, just based on you know, if I could stay here for a week or stay upstairs, or we just work it out just to, like I said, survive, keep the house, and that was the sole purpose from the get go. But I also, like I expressed to him, I did provide some letters from people who have visited me who've noted those living conditions. So you know, and then I'm jumping all over the place a little bit, but then I guess going also when he asked for you know, documentation for the 4010 compared to the 40102 as far as bills were concerned and what's going to what address. I had a conversation with the city, and I said that was a mistake from the get go when I did apply. As far as I just had 4010, so it wasn't unit 1, it wasn't unit 2. Um, it it was a mistake, but it was just 4010. So as far as the bills were concerned, I said, well, I said, I'm not sure what you guys want me to do. I could send some bills down there where I'm living, and it seemed like it didn't matter. I mean, so that, as far as that was concerned, it wasn't. I didn't feel like I needed to make that change. I mean, it is. I do grab my mail where the front door is, anyways. So it's not like, because I do use both units, that was discussed. So, but I mean, as far as proof's concerned on your end, I mean, I can see that, but like I said, I'm just asking the city to work with my situation, and just kind of see where my situation is currently. You know, with the state of housing, the price of housing, for me to move on from my situation, marital wise, and this enables us just to supplement more income. And because it's hard for me to put the long term tenant in there, um, is the reason for the shared in the short term. So yeah, appreciate your time, but that's basically what I want to touch on.
Thanks, Ryan. And just a quick question is, did you have anyone else speaking for you, a witness this evening, or is it just yourself?
It's just myself tonight. Yeah.
Okay. In that case, I'll give an opportunity for the panel members to ask you questions, followed by the City of Vancouver Council.
Okay.
Panel members, if you have questions, please put yourself on the queue. I'm not seeing anyone on the queue. Okay, maybe then I'll turn it over to Robert LeBlanc. Do you have any questions for?
Sorry, Chair. I think we just got a couple last minute.
That's okay.
Yeah.
Yes.
Sure. I'll just
go ahead. Hang on, Councillor Bly. Just one moment. Yes, sorry, I didn't see either of you on the queue when I called. So go ahead, Councillor Bly.
Thank you very much. So my question, Brian, is in regards to this missing information that you feel has not been submitted. Is that something that you have with you? I don't know the process here, Chair. I'll also ask that you guide us. But if there is a claim that there's missing information in this submission, and that's available and sounds like it ought to be considered by the panel according to Ryan's testimony. I wonder if that's available or what the process would be there.
I'll look to our staff for comment on that. Or perhaps Ryan, sorry. My apologies, that's to Ryan. So.
Oh, that's a question for myself. Yes. Right. I could provide some of that information. Yeah. What were you referring to exactly?
Well, I had the same question for you. You've made quite a few suggestions that city staff do not have, are missing sort of key pieces of information in this submission to this hearing, and I'm wondering what specifically is that, and can you back that up?
Oh, sorry. Okay, so as far as I submitted a couple letters backing up my case from people who have witnessed my situation. Is that what you were referring to?
I guess so.
Yeah.
It
So
was vague.
I submitted that during the audit.
Okay, do you have copies of those letters that you could submit to the clerk?
At this current time?
Mhm.
Yeah, I'd have to pull up my email.
Well, this is your hearing, so it might be in
Yeah.
your interest.
Okay. I just thought those would be on hand, just like everything else. But
Well, I think if staff have them, we would have them in our package. If you're claiming that they're not there, then we don't have them.
okay. Yeah. No, I'm not claiming they're not there. I just claimed that they weren't presented by the speaker. So
So we'll, I'm going to interject. So
Yeah.
Ryan will, so Councillor Bly, you've requested that information. It sounds like Ryan, you're going to look for those letters and that those, it sounds
Yeah.
like they were witness emails.
yes, they were.
And you have the clerk's contact information, is that correct?
Can I get that information?
Okay, the clerks are gonna email you, so you get, you know who.
Okay.
Yeah.
And then I'll just go on.
Yeah.
Okay.
While you're doing that, Councillor Bly, do you have further questions?
I'll leave it there for the moment. Thank you.
Thank you. Councillor Fry, to the licensee.
Yeah, thanks, Chair, and thanks, Ryan. Ryan, I'm looking at your Airbnb listings now. How did you interpret the suspension of your license in October? And the fact that the city would not give you a license to operate in 2022, and I'm now able to book a space on your Airbnb.
I just determined it based on because it was in the appeal process. So I just felt like any other appeal that until the hearing and decision is final, that it was no different than when they were auditing me to look to suspend my license possibly. So and I did. So that was my understanding. So because it was
Isn't the condition of submitting your property on Airbnb that you need a license, a valid City of Vancouver license? I'm just trying to walk through this because I was of the impression that Airbnb needed a license, a valid license, in order to put your listing up.
Yeah, I think that's an Airbnb question. I think for them, I think if I went too long, they might communicate with me. I think they because every city has a different bylaw. So like I think they were allowing me to operate the same way. And like I did note, I did call into the city, and because I did try to renew because the end of the year was coming up, and obviously it wouldn't allow me to because we were in this appeal period, right? So
Yeah, no, we see the notes here.
Yeah, so that was my honest understanding. I thought, and I actually asked them. I said, "Do you have a rough timeline when when I will hear from the city as far as when the appeal hearing will take place?" And she was like, "Oh, it should be soon," and all this stuff. So I just honestly I felt like okay, because it's an appeal, I felt like until the hearing, it should be okay at this point. As far as the Airbnb side, they never contacted me about asking me about that at all. So
okay, so just so I'm clear, then you're once and done when you submit your application with Airbnb, you give them your license. They don't follow up year after year to make sure that you have a valid annual license.
they actually no, they do, and they'll just give you a notification saying um, to show an updated thing. I think they basically I can't remember. They'll give you like an email sort of saying, hey, it's kind of the year is expiring and whatnot. But my understanding is I don't think they remove you. I mean, they're in the business of
Sure. Yeah. No.
just trying to keep hosts, but but as far as I was concerned, I was honestly waiting for the hearing, and then so I just felt that it was okay, just because I thought when I got the suspension notice, it said, but you have 14 days to appeal, and felt like any appeal, like, okay, you can kind of, if you're suspended, you can go, go on with. If you appeal, then it's like a delay in a way, and then wait until we actually are allowed to have a hearing. So that was my honest understanding.
No, that's fair. I mean, I think maybe that's
Yeah.
something to be, we need to work on articulating if that's the case, because I think a suspension of, obviously, if you don't have a license to do business, you don't have a license to do business.
I understand.
Okay, thanks, Ryan. Those are my questions, really. Thanks.
Thank you, Councillor Fry. Just before I move to Robert LeBlanc, just again noting, Ryan, that the clerks have emailed you at the address on file. And so if you wish to send those additional letters or emails that you referenced that Councillor Bly inquired about, I would encourage you to do so now.
Okay, yeah, I'm sorry. It was hard
Yeah.
for me to multitask.
No problem. I just wanted to flag it for you.
Okay.
So the next part of just this portion is that Robert LeBlanc, who's representing the city, has an opportunity to ask you questions as a licensee. So I'm going to turn it over to Robert LeBlanc.
Thank you. Mr. McMillan, I'm just looking at page 66 of the evidence package, and this is your dispute hearing notice indicating that you wish to appeal the Chief License Inspector's decision to suspend. In your last paragraph, you state, I also have people who have visited me that know my personal situation and can back me up on this and how we are falling in line with the short-term bylaw. I am prepared to provide documents at the hearing if I am provided one. We're at the hearing today. I haven't received any documents. Have you submitted any documents?
Oh, I did. I'm gonna forward. I'm gonna forward you the documents right now. I just got them in front of me here.
Okay, who did you submit them to?
I submitted them to. Okay, the City of Vancouver short-term rentals at Vancouver.ca. So that was the communication I had. So when they had I think your letter. Sorry, this was the email that sent me the. Sorry. Oh, sorry. I was letting them know about the appeal, and then they responded. So I replied. They just asked for further documentation. So it looks like the city clerk, but I just responded to the email. So I mean, I can send you like they sent me the appeal letter, and then I'm just looking at it. Sorry, and then I sent them further documentation, and I'm sending that over to you right now here.
Thank you, Ryan. Robert, does that address your first question?
It does. Well, we'll have to wait and see those documents maybe before I.
Yeah, they're coming. Sorry.
And we could certainly, if need be, entertain a very brief recess to permit time to send those documents.
Okay.
I'm going to suggest that we take a 5-minute recess. So it would allow Ryan, that would give you time to send those documents and emails so that you're not trying to do that while we're asking questions at the same time. I think does that give you enough time, Ryan?
I appreciate that. Yeah, I would.
Okay, so we will resume at 7:45. Is that correct, clerks? So just stay on the line, Ryan. We'll wait for you to do that.
Okay. Great.
you.
Thank you.
Those are my only questions for Mr. McMillan. We may want to just ask Mr. Miyagi if he's seen the documents or whether he knows the email address it was sent to.
Yes, I'll invite Koji to return to the podium and maybe address that question. Thank you.
Yes, Madam Chair, we have not received, or to my knowledge, we have not received these documents. The email address that he states sounds like the short-term rental, the general email that we would correspond back and forth with. I spoke to the clerk this morning, Andrew, and had asked him if we had received any new information from Mr. McMillan. Now, that was this morning. And at that time, he has stated no. The last communication we got was what was cited in the memos that we provided as part of the evidence. So, to my knowledge, we hadn't received the letters that he's indicating.
Thank you. Thanks for clarifying that point. And you have no further questions, Robert LeBlanc. So in that case, I believe we are moving to closing. Go ahead.
I am on the queue.
Yeah,
Sorry.
Sorry, Councillor Bly. Go ahead.
No, it's okay. I just wanted to, I guess why this has come up is in the letter, and this is just about tracking how this information flow is happening. And so there is a letter, it's not dated actually, where Ryan McMillan does say that given the opportunity, I am prepared to provide documents at the hearing if I'm provided one about people who have visited me that know my personal situation can back me up on this. So I don't see that I just don't see, based on the documents that we have in front of us, that we were expecting these documents ahead of this hearing, but we're at the hearing now, and it reads that. So I just want to clarify that, just so we're not talking about, to me, when I read this, that there were documents forthcoming at the hearing, and now we've received them. I just want to clarify that.
Okay, thank you. Is that specifically a question to Mr. McMillan?
Well, no. I'm happy to have our city staff either affirm that that's how these documents read. There seems to be some confusion as to what email Ryan submitted them to previous, but how I read this letter is his intent was to share them at this hearing if provided one.
Okay, thank you. Koji's at the podium. Go ahead, please.
Yes, Madam Chair. It does state here in your package, November 5th, Ryan sent an email with 2 attachments, one letter from his friend. So that's the one that we must have received here, while the second was corrupted. So that's the one that we cannot open. And your response to this email asking Ryan to resend the file. Ryan resends the documents. Both appeal documents are available at VanDocs. So it is cited. And my apologies. When I spoke to Andrew this morning, he said he hadn't received anything new because he's already cited that in here. So we hadn't received anything outside of what was cited in the memos that he provided. So sorry, it's on page 8 that he did submit these documents, and it's in VanDocs.
Thank you for that clarification. Councillor Bly, does that address your question?
Yes, that's very helpful. Thank you very much.
Thank you. Robert, I'll turn it over to you for closing submissions by Council, City of Vancouver Council.
I'm going to ask the panel to just refer to the dispute letter that was filed by Mr. McMillan to appeal this process. I've already read from the second last paragraph. This is at page 66. And Mr. McMillan says something in the end of the third full paragraph that I have to point out as an error in terms of this particular process. What Mr. McMillan says is, it seems like the rental division is basing their findings on my living situation with a lot of he said, she said, and have provided zero proof that I have broken any a bylaw at all. That, in effect, is a suggestion that at this stage, the onus is on the city to prove that this is not Mr. McMillan's principal residence. That is not the purpose of the audit process, and that is not the purpose of this particular hearing. The bylaw that was adopted by council very clearly sets out an audit process that the chief license inspector can undertake and request documents and evidence that a licensee may have in support of their contention that they are the principal occupant of a residence. And it's on that basis that it is expected that that licensee furnish persuasive evidence to establish that fact. The onus is on them during the audit process. And this panel needs to ask, what did Mr. McMillan supply that would lead the chief license inspector to conclude that unit number 2 was his principal residence? As I've already set out, and I think Mr. Miyagi has set out, is that the evidence that the chief license inspector had to go on during the audit process was evidence of extremely high booking volumes, was evidence that this was for full-time rental of the entire unit with no supporting documents to the contrary. Nothing furnished by Mr. McMillan, by the licensee, yes, Mr. McMillan, indicating that some, if not all of these, were shared rentals. There was no update provided with respect to the last request for occupancy numbers. There were no documents provided indicating that he was the principal residence of the basement unit. No bills, no insurance, no driver's license. What we do have is his assertion, but that is inconsistent with any of the supporting documents that have been provided. There's a vacuum there. So the question for this panel is not, do we reweigh this evidence and give Mr. McMillan a second kick at the can and go to this great expense to bring everybody here and effectively replicate the process that we've enacted through our bylaw should be done by the chief license inspector? Or do we defer to the chief license inspector and determine whether or not her decision was reasonable on the evidence that was submitted in the appeal process? And that's the role of this panel. This panel needs to take a look at whether or not the chief license inspector made a reasonable decision based on the information that was before her, or whether she made an error in any of that. And respectfully, no error has been shown. And I'll reiterate the fact that there is a complete absence of evidence that Mr. McMillan has submitted in support of his contention that he occupies unit number 2 as his principal residence. So, not having found any error and determining that it was reasonable on the evidence that was available to her to make that determination, this panel ought to defer to the decision of the chief license inspector because it has empowered her to go through that process, to effectively give applicants a second kick at the can, incentivizes them to come to this panel and review all of these chief license decisions so that they can try and persuade otherwise. I don't think that that's an incentive that this panel should be giving. We shouldn't be reweighing new evidence or evidence that was previously submitted. We need to constrain this to the real questions. And the real question is whether or not it was a decision that was reasonable, and whether or not there was an error that was made. In my respectful submission, it was a reasonable decision. No error was made. I will address the issue with respect to the door. I know the case that was referred to, the interconnecting door. I did not deal with the business license hearing. I did, however, deal with the prosecution of the matter. I don't know exactly what the submissions were made in the course of that hearing that was before this panel. What I can say with most certainty is if the approved state of a property is such that there are 2 dwelling units and one of those dwelling units is being offered for short-term accommodation, then that dwelling unit must have a short-term rental license that is held by the principal resident of that unit. So in this case, unit number 2 requires a business license from the principal resident in order to conduct short-term rental accommodation. In this case, the chief license inspector has determined that the person holding the license does not qualify as the principal resident of the unit, and the suspension was issued on that basis. And again, I'll just reiterate my first point that this all gets put through the lens of the intention of the city is to preserve these units for permanent housing stock. That was the approved use of this particular unit. And if we don't have a principal resident, then we don't have long-term housing stock. Those are my submissions.
Thank you for those closing comments. I'll now turn it over to the licensee, Ryan McMillan, to make your closing submission to the panel. Go ahead, Ryan.
Thank you. No, just my closing statements is, look at my particular situation, not as a whole. Based on my circumstances, I had 2 letters that were backing my situation, and the fact that we're trying to make ends meet at this point. Like I said, if I could rent it out long term, I would, but my current situation personally, it makes it very difficult. And so I'm just asking the panel to take those into consideration. I'm not, I'm not trying to, run a commercial, business that's bringing in a lot of money. It's on par, if not sometimes less, to be honest. I'm just trying to have flexibility with my current situation that has been discussed with the city this last while during the audit. So yeah, I just kind of ask you to kind of take that in mind and look at this particular situation. It's a little unique. But yeah, and just thank you for your time and respect your decision.
Thank you, Ryan. I appreciate that. So this means this time we're moving to discussion by the business license hearing panel. And so looking to panel members for discussion on this item. And then after that, a decision. And is there any discussion?
Chair, I'm happy to. I'm just actually looking for the wording here. So we don't need the motion just yet. We could just discussing.
Oh, we can discuss it this time, and then I understand that we'd be seeking a motion. I do see a motion that's been circulated by Councillor Fry, but this will be a last opportunity if there's any further questions or clarification needed as well.
Oh, okay. I'll hold my comments. Thank you.
Okay, thank you. I could entertain a motion then, I believe at this time, and the clerks will correct me if I'm wrong, but I believe it would be appropriate at this time. I see Councillor Fry on the queue. Go ahead, Councillor Fry.
And thanks to the staff team and legal representation for assisting with this today. And thanks, Mr. McMillan, for joining us in your appeal. I have submitted a motion to uphold the chief license inspector's decision on the basis for 3 reasons. The operator is non-compliant with the conditions of the short-term rental license. I think that's been established. The short-term rental accommodation does not meet the definition or spirit of principal residence unit of the operator. And the operator has and continues to operate without a valid short-term rental license. So on those grounds, I do think that upholding the chief license inspector's decision is the appropriate course of action here.
Thank you, Councillor Fry. So that motion has been moved. Can I get a seconder for that?
Second.
Seconded by Councillor Bly. So that is on the floor and now open for further discussion and comment. Councillor Fly, do you have anything further?
You know, only that I have obviously looked up the McMillan's Airbnb listing and appreciate that they've provided a quality product and they've been recognized as a superhost, and so it seems to me that it has been a successful business venture for them. That's not necessarily germane to this decision, but I think I am troubled when folks are operating a business in the city of Vancouver without an appropriate license. I think that's a bare minimum requirement, and I appreciate that Mr. McMillan may not have understood that a suspension of the license meant that he had no license and he was unable to continue doing business in the city of Vancouver, but that is in fact the case. And I suppose the only closing thought I might have is that I am going to follow up to make sure, and I think it behooves us to make sure that Airbnb is following through with the MOU for short-term rentals and are in fact identifying that licensees who are submitting onto their platform do in fact have valid City of Vancouver short-term rental licenses. Because if the case is that they are, as it clearly is the case, that they have taken Ryan McMillan's Airbnb and posted the listing despite the fact that he had his 2021 license suspended and he does not have a 2022 license, and I'm currently able to book accommodations at Ryan's suite this month, next month, and in May, I do worry that the MOU that we have between Airbnb and the City of Vancouver is not being respected to the full extent. So that's something I'll be taking away and asking for an update from staff.
Thank you, Councillor Fry. Councillor Bly, go ahead.
Thanks very much. So I will be supporting the motion on the floor to uphold the Chief License Inspector's decision to suspend the license. And, you know, in addition to Councillor Fry's comments, I also appreciated the comment regarding the challenge we face at public or at business license hearings is that decisions that we make here send a message, and it would be extremely problematic if we had a flood of appeals based on what is, as Councillor Fry laid out, a violation of the short-term rental bylaw in terms of how it's been interpreted and applied in this context. All that to be said, you know, Ryan, you did come speak to your own hearing and defend your position, and I do, of course, have empathy for the personal situations that you're in that have caused maybe a lapse in being able to completely provide documentation and all the things that need to happen in order for you to be compliant with the short-term rental bylaw. So I'm not necessarily so invested in understanding exactly where you're living for what amount of time. I think there's a limitation on our bylaw that we should be able to have clear guidelines in terms of how many days per month and or how many days per year one is able to rent out under the short-term rental bylaw. So that is something that I'm taking away from this. But ultimately, it's clear that there is a lack of compliance when it comes to this particular business license as it relates to this address. And so I'll be supporting the motion on the floor. And I do wish the defendant, Ryan McMillan, the very best and hope that things settle down. Personally, of course, but this is the responsibility, I would say, of this business license hearing to uphold the recommendation from the chief license inspector. So I'll be doing that today.
Thank you, Councillor Bly. And for myself, I will also be supporting the motion that's been tabled. Similarly, I've been compelled by the information that's been presented this evening as part of the business license hearing, and that there indeed, if we're dealing strictly with the bylaw itself, that there is a lack of compliance. And like Councillor Bly, empathize with the licensee with respect to his personal circumstances. But recognizing, as our council noted, the onus being on the license holder here, and again that noting that it's there's not information with respect to the principal residence. And so I will also be supporting the motion. And so I am simply going to call a verbal vote on this because there are only 3 of us here on the panel. All in favor of the motion, say aye. Aye.
Aye.
That motion carries. Thank you. That brings us to the end, and thank you, Ryan, for presenting this evening as well, and our staff who've also been here this evening. I will just seek a motion to adjourn at this time.
Motion to adjourn.
Seconder?
Second.
Thank you, Councillor Fry. All in favor?
Aye.
Aye. That motion carries. This hearing is adjourned. Thank you, everyone. Have a good evening.
Thanks, everyone. Good night.